Hi, everyone. Happy holidays, Merry Christmas, Happy Early New Year's, all that good stuff, whatever you may celebrate. Before we even start, I want to make sure to wish you all a happy and healthy holiday season. I hope it's filled with joy. We're going to talk about some things that may not be as joyful, and that's your questions. So presumably some of these questions are born out of frustration. I have tweaked some of the questions, just to make them more applicable, perhaps. And some of them I've kept just as is. A couple of them I cleaned up the language. In any event, we're going to go through questions that were submitted today. And if you have questions as we go along, feel free because we'll try to cover everything that gets submitted here. And I promise to stay till the last question is hopefully done. So, do you have questions about employment law? The answer is always yes, right? Because it's always evolving. For those of you who don't know me, I'm Ann Lavelle. I am the compliance specialist here at CTR. Before I did this, I worked at a law firm. I was a partner in the labor and employment section for almost 25 years. And I retired because I was tired and I wanted to spend more time with my kids. And so I always enjoyed the educational part of things, doing trainings for employers and an ounce of prevention so much better than defending lawsuits for everyone involved. So here at CTR, here's a brief advertisement of what we offer. A lot of you are already clients, so you know what's out there. But for those of you who aren't clients, it's a little plug for CTR. All right, the first one. Hey, I am so happy that some people read our social media because I put this together every week, and it's called What's the Issue? And that trendy title came because it gets published on Wednesdays. What's the issue Wednesday? How I'm so trendy. What can I say? So I'm glad you enjoy reading those. And they tend to deal with legal updates, not always from Pennsylvania, but things that are applicable to all employers everywhere. And so there was a post about the PA unemployment comp system. And that's something probably everybody on this call, on this webinar, has had to deal with. And it does evolve, not very fast, but there are changes to it now and then. And essentially, I cleaned up this one a little bit. The person referred to the employee as being butthurt. But what are you really telling me is what this question said, that an employee who voluntarily resigns from a job, not fired, could work forever, can get unemployment compensation because essentially their feelings were hurt. So let's break this down. First, let me give you the background on this case that came out. There's more to this than just somebody having their feelings hurt. So in Pennsylvania, as probably many of you know, if you terminate somebody, generally they can get unemployment unless they have really engaged in some sort of pretty serious misconduct. And so things that we would look for like theft, right? If you're going to steal from us as the employer and we fire you, you really shouldn't get unemployment. That's not right. However, if you're just incompetent, then yes, you're going to get unemployment benefits. If it's a layoff, if it's a downsizing, they're going to get benefits. It's not their fault. You may argue that incompetence is their fault, but the unemployment comp system doesn't see it that way. On the flip side of this, yes, it has always been possible if somebody voluntarily resigns to get unemployment if there is what we call necessitous and compelling reasons to quit a job. And typically, that's a pretty high burden of proof for the employee to establish that they had to quit in order the job for some reason. And so things that have held true in the past include things like pervasive sexual harassment or discrimination or physical abuse. Unfortunately, that has occurred where a manager throws things at an employee and hurts them or whatever it may be. Those are necessitous and compelling reasons. Not paying the employee for an extended period of time can be a necessitous and compelling reason. So that makes sense, right? usually those issues are over a significant period of time, right? So it's not just because somebody said, "Hey, Ann Lavelle, um, I don't think women should be attorneys." That's one comment. That probably does not constitute necessitous and compelling reasons for me to go get upset and quit my job. However, we have a situation here that came out of a small community where there were two courts that both agreed it was necessitous and compelling reasons, despite it only being one occasion where the person was not talked favorably about. And this lady had been with the employer for over 10 years. It was a municipality. And for whatever reason, she sent out a letter to some of their drivers, like their plow drivers, telling them that they weren't keeping their time correctly and to do better, essentially. You could argue whether that notice was her responsibility or not. You could argue whether or not she used the right amount of politeness in that notice or not, but it wasn't horrendous by any stretch of the imagination. Um, the head of the municipality at an open community meeting, like their regular monthly meeting, decided to rip on her. And her husband, also, this is a small community, right? Her husband was also employed in the municipality. And so the head of the council, the town council essentially, called her stupid and questioned her competency at the job at this open hearing, right? And basically said he wished he never hired her. Now, those comments in and of themselves, if they had been behind closed doors, um, not polite comments to call somebody stupid, certainly, not the most effective HR technique I've ever seen to improve performance, might not have gone anywhere. But this was an open meeting. And keep in mind, it was done by the head person of the town council. She and her husband resigned in response to the comments, because the comments also went directed towards her husband and, basically informed him he was stupid as well. Must run in the family. In any event, the head of the town council eventually apologized to the husband, and that job was sort of salvaged. But the head of the town council did not apologize to the woman. And so let me just make sure everything is good here. Okay. I will get to all these questions in a second. I want to be respectful of everybody's time too. So I promise I see the question. I will get to it. The head of the council did not apologize to the woman, and the woman resigned and said, I can't work here. If you think I'm stupid and you should never have hired me and that I'm incompetent, I'm not going anywhere with this job. She then filed for unemployment compensation. And the municipality fought it, saying, hey, that wasn't necessitous and compelling reasons. It was one meeting, a limited set of comments. Your butt hurt, basically, and you shouldn't be getting unemployment. And two courts, a lower court and an appeals court, agreed that the woman actually should get unemployment. And they hung their hat on a couple of things. One, the public nature of the comments, right? Even though municipality meetings generally are not well attended by the community, nonetheless, this was said openly in a place where it could be recorded. It's a small community, news travels fast. And also, the court's sort of biggest problem with it was the head guy, right? There's nobody she could appeal to and say, hey, Joe said this about me. He's being mean. We need some help here, whatever. There was nobody for her to appeal to. This was the head sort of chair of the board. And the court said any rational person would look at that factual circumstances and say, my job is done here. I may as well resign. What does that mean for us as employers? I think it means we need to be careful how we do things a little bit. Fingertips are sometimes required. We could have put her on a PIP, right? A performance improvement plan. And that would have been a no-brainer to do if we thought she was doing things wrong with the drivers and sending them messages that she shouldn't and whatever. Um, Personnel matters really should be private. We shouldn't be disciplining people in front of the whole entire world. And so I think if we translate this to our own workplaces that aren't municipalities with open hearings or open community forums, the takeaway here is you discipline in private, right? I could see somebody trying to analogize this to a situation where a manager chews them out in front of their coworkers. Hopefully, there is a level for them to raise the concern when this happens. There was not for this lady. And so I think we've all seen a situation where somebody's been kind of harshly disciplined in front of others. I was in a grocery store about a year ago and I saw a manager chewing out a very, very young employee. The manager might have been right about what the employee did in terms of bringing in grocery carts, but to do that publicly when I'm in the fruit aisle, um, probably not a good idea. And I think that type of situation, if the person walked out, might lead to unemployment comp benefits. So, not a huge change in the law. They always could get benefits for voluntarily resigning for necessitous and compelling reasons. We've just expanded the idea of what necessitous and compelling reasons are to include sort of public discipline by a person who's kind of high up. Okay, moving along here, assuming my computer cooperates. All right. Yes or no? Not maybe. So this was a popular one, and I kind of condensed it. Am I required to offer transgender bathrooms? Well, let's turn that question a little bit. We don't have a bathroom labeled transgender. We either have a single use bathroom sort of idea where either gender can go in, and it's single stall, whatever. That should be no problem at all for anybody at any time, no matter whether you're in a blue state or a red state, federal law, state law, that is a great solution if you can swing it, but a lot of employers can't because they have older buildings that have the ladies' room and the men's room. And so, what do you do with that? And nobody likes the legal, apparently nonsense answer of it depends. Here's what I would say. I think if I had to look into my crystal ball, that you're going to have problems allowing a person to use the bathroom of the gender they identify with come about the third quarter next year. And here's why I say that. And again, I just report on this stuff, so I'm just a messenger. The Supreme Court has agreed to hear two cases, one of which is out of West Virginia that involves schools. And West Virginia and the other case, both states had bans on trans athletes competing in a sport in the gender that they identified with. So if I was biologically female but identified as a male, I can't go run on the men's track team in these states. Those cases have wound their way up to the Supreme Court. They're going to be heard early in 2026. We have a conservative court. That's just the way it is. And I think they're going to, based on their decision in Scrimeti, where they said, hey, you can ban trans care for kids under a certain age till they're adults. I think we're likely to see a ban on that upheld in the sports context. And that's just one step away from the restrooms and the locker room issues. That case will directly impact educational institutions, but the same logic from the Supreme Court will apply to other things. So I think you're going to get a much clearer answer in 2026 on this. The problem you have right now is you're in an untenable position because you have Pennsylvania would say, let Anne go to the men's room if she identifies as a male. But federal law says the opposite, or at least federal guidance right now. Guidance doesn't have the same sort of oomph as a law does, but you're in a catch 22. So unfortunately, I really can't change my answer, but I can give you some direction that I think in the next 6 to 9 months, we're going to have a very clear answer on this, or clearer. With the government, you never know if anything's completely clear. And federal law will likely trump any of the state laws that are out there to the contrary. So keep your eye on the Supreme Court. You're going to get some clarity on this. I'm looking into a crystal ball that's often is fuzzy, so I could be very wrong. But I think given the conservative nature of the court and the history of the court in the Tennessee case, this issue might be a lot clearer for you then. Okay. Yeah, I know. I still gave the it depends answer. Okay, you can see what generation of music I'm from for those of you who know Vanilla Ice. Yes, I'm from the 80s. Okay, so if ICE shows up at the workplace, what are an employer's legal obligations? So we're not talking about whether ICE is right, wrong, the best thing that's ever happened to the country or the worst thing that's ever happened. I try to stay apolitical in all things. But this is a really good question. What are we legally obligated to do? So a couple of thoughts here, and part of this involves record keeping and how you should keep your records. So first of all, if ICE shows up, they are allowed without warrant or subpoena to be in any public area of your business. Now, for some companies, there is no real public area except for maybe your lobby. For other businesses, like some of the restaurants that have made the news around here, there are public areas, right? I can walk in as a customer and sit down and have a meal. That's a public area. So that's point number one is if you think you're going to say, get out of my building, you're not allowed without a warrant or a notice of inspection. They have different things that they call it depending on what they're looking for. They are allowed in your public areas. Item number two, if they want to go in the private areas, then they do need some type of warrant or notice of inspection, depending on what exactly they're doing and what they're looking at, to go in there, right? And so if they want to go into your manufacturing facility or back in the kitchen or whatever it might be, they need something in addition. If they have that, you're going to be really hard pressed to do anything about that unless you somehow have your attorney on speed dial who can get the court on speed dial, and that's not realistic. So you're going to have a situation where you're reactionary to it, and you want to think about your social reputation out there, wherever you come down on things and wherever you think your customers would appreciate or not appreciate where you come down on things. But you're not going to go get that warrant quashed or the subpoena or whatever it is in a very quick manner. What is a notice of inspection? So this gets the record keeping issue. They have a right, assuming they have a notice of inspection, to come in and look at your I-9s. And we actually got a question about I-9s that we'll get to. It was a great question. But your I-9s really should be separate and apart from the employment file. I've said this before because the notice of infection, that was a slip of the tongue, I promise. The notice of inspection will say that they're entitled to look at the file that has the I-9. If the I-9 is by itself, which it should be, and is separate and apart from the employment records, the employment file, that gives them a lot less to look at. So it makes their job a little bit harder. And regardless of where you stand on immigration, the general philosophy, even before we had all the ICE issues and raids and whatever, was you always keep the I-9 separate because you don't want to hand the government other issues to look at you for. And if you have the DHS or ICE or whoever it may be coming in and looking at things, you give them a responsive but minimal amount of information to look at. Okay, so moving along here. FSA, flexible spending account. So it's benefit time this year, right? Flexible spending account. So somebody's been listening to me, which I appreciate because sometimes I wonder if I just talk to myself. I know at my house, I only talk to myself and my kids aren't listening, but that's a different story. I have great conversations with myself. That's okay. I have mentioned, and somebody has picked up on this, that flexible spending accounts are by definition self-funded plans. And somebody said, hey, you keep mentioning that, but what exactly does that mean? And I'm sorry if I haven't been clearer on this before. So a flexible spending account, if you have one, covers things like co-pays, your co-insurance, whatever it is. And the employee at the beginning of the year elects, I want to contribute, $1,000, whatever it is, up to the cap, to this. It's considered, if I don't use it, I lose it because it's considered funded at the beginning of the year. So if I had a huge expense at the beginning of the year and I blew through all the whole thousand in January, even though I've only contributed, $90 so far to the thing, I get the benefit of that. It's fully funded. I get to submit the claim for the full 1,000. But what does this mean to employers? Well, a self-funded plan, whether that's a health insurance plan in the traditional sense or an FSA, comes with additional legal obligations. And so, with a fully insured health plan, which often accompanies an FSA, the insurer takes care of a lot of the legal malarkey. I don't know what you want to call it. A lot of the legal obligations that come with it that nobody ever reads, but are important to have. And so the fully insured plan takes care of HIPAA. It takes, because all health plans are HIPAA covered entities. It's not just the hospitals and doctors of the world. Oftentimes they'll give you like a form plan document or whatever it might be that you need to fill in the blanks. You attach the member booklet to it, and you sort of have a canned plan document. Not the best thing in the world, but not bad either. So with an FSA, you are probably doing this unless your TPA is extremely helpful in helping you. TPA is a third-party administrator helping you to be HIPAA compliant and have the right plan documents in place and all that good stuff. The other thing to keep in mind is that all self-funded or self-insured health plans, of which an FSA is one, are subject to non-discrimination testing. And I've talked about this several times, but that non-discrimination testing has nothing to do with the typical discrimination claims that we see in employment law. So we're not looking at, hey, did we cover Ann who's white, but not Joe who's black? What we're looking at is, did the plan favor our highly compensated individuals in the workplace? And the reason we have non-discrimination testing for that is the idea is sometimes employers price insurance in a way that the folks who are at the bottom rung of the organizational chart can't afford it. And so what you see happening is all the executives are in the health plan and the FSA and whatever else, but everybody who's lower on the org chart is not. That is considered discriminatory. And there's very specific tests that you can run to do this. Sometimes TPAs will run these tests for you. Oftentimes, you have to find a benefits counsel or benefits provider who is well versed in this and can run the test for you. The potential evil here is, let's say your plan, whether it's the FSA or whether it's a full-blown health plan, favors your highly compensated individuals. And depending on the test you're running, that's usually the top 5 to 10% of your wage earners. The benefits that they got tax-free, whether that is the $2,500 they put into the FSA, or whether it's the CEO's heart surgery that cost, $250,000, all of a sudden are taxable benefits to the highly compensated individuals. And that is a really unfortunate situation when it happens. It used to be that these rules were not enforced well by the Department of Labor, who's responsible for this. They are more robustly enforced, not across the board, but there's certainly more enforcement activity. So if you have a self-funded plan of any type, whether that's a FSA or a health plan, you need to be cognizant. If you think you're top heavy and that it looks like, gosh, the CEO, the CFO, the COO, and everybody right below them are in the plan, but our line workers aren't, forget the Affordable Care Act for a second. You've got an issue with a discriminatory health plan that could really come back to bite people on an individual level. So that's why I harp on an FSA being a self-funded plan, because all self-funded plans have this issue, including FSAs, that they're subject to non-discrimination testing. Okay, we've beat that dead horse. Let's go on. Pregnant Workers Fairness Act. What about changes to it a second? Is he going to veto it? No, he can't veto it because it's already a law. However, where you'll see the changes, and the Trump administration has already promised some of these changes, is in the regulations and the regulatory guidance that's out there. So if you remember back in 2024, and some of us, like myself, can barely remember what we do, like yesterday, but back in 2024, the EEOC, the Equal Employment Opportunity Commission, which is a federal agency responsible for enforcing this, issued a boatload of regulations. And so we have a general law out there passed by Congress, the PWFA, that says, hey, you got to give women some accommodations when they're pregnant. They shouldn't have to lose their job just because they're on bed rest or something like that. So we have this general law that says we're going to do good things. And then the EEOC came out with just tons of regulations about what that could look like. And that included a couple of things that a lot of employers objected to. And again, I just report things. One of which was the concept that a reasonable leave of absence was at least 40 weeks. So the length of a pregnancy is 40 weeks, right? And the EEOC was floating the idea that the length of the absence should actually be 52 weeks. Because if the person was incapacitated at the moment of conception, you would have 40 weeks of pregnancy plus 12 weeks of recovery. So that gives you roughly 52 weeks. A lot of employers said, hey, that's an unreasonable length of time, 40 weeks or 52, pick your poison. It's too long to be an automatic unpaid leave of absence for somebody. So the Trump administration is looking at that, and they have expressed skepticism as to whether or not that truly is reasonable, 40 or 52 weeks, or whatever number you want to pick. The other thing, and this is controversial, of course, is the law was expanded, or some people might say inherently included, depending on which side of the fence you're on, abortion recovery, time off to have one, time off to recover, time off if you had complications. And so some folks, both employers and just individuals, said, hey, this law was meant to help pregnant folks, pregnant women. By definition, somebody who's had an abortion they're not pregnant anymore. And again, depends which side of the fence you're on, how you feel about this. And they said this does not fulfill the intent of Congress. Congress was looking to protect people who were trying to carry a pregnancy to term. Again, depends which way you look at this. And so what had already happened, even before Trump stepped into office, was there was a decision out of the Fourth Circuit. An employer with deeply held religious beliefs said, I'm not giving people time off to have abortions. That goes against my faith, my beliefs. I'm just not doing it. Again, you can love that decision or hate it. That's not what we're here about. And the courts agreed with that employer that this law was infringing on that employer's deeply held beliefs by expanding this to include abortion protections. This, as some of you may remember who have been around the block more than once, this is akin to the decisions in the Affordable Care Act about contraception coverage. If you recall, there were some cases involving Catholic charities and Mennonites and some other folks who said, hey, we have non-religious businesses, but they're run by religious organizations that have deeply held beliefs about contraception and not permitting it. And the Supreme Court agreed with them and said, no, we can't. This is like the Hobby Lobby decision type of idea. No, we're not going to require folks with deeply held beliefs to violate those beliefs with respect to contraception. This is the same idea. So even before Trump stepped in, the courts were saying, that portion of the law on the Pregnant Workers Fairness Act could not be targeted or enforced against or employers who had deeply held religious beliefs about abortion. The Trump administration stepped in and said, we aren't going to enforce across the board, not just in the Fourth Circuit, which is like Maryland, West Virginia, et cetera, that issued this decision. We're not going to do this across the board. And we promise you change is coming with respect to the scope of what these regulations purport to cover. So it's going to narrow the scope. It's probably going to reduce the abortion protection in the law. It may reduce other things too, because if you recall from some of our fun webinars and seminars, this also covered things like menopause, arguably, which clearly you're not pregnant if you're in menopause. Gosh, I never thought I'd be doing a health lesson. In any event, you're going to see a narrowing of the scope here and a reduction in the enforcement efforts with respect to some of the things under the Pregnant Workers Fairness Act. So keep tuned. That's coming out. Okay, I Spy. Who should conduct workplace investigations? So got this question. I'm going to assume we're talking about like a harassment or discrimination workplace investigation and not somebody may have stolen money investigation. So oftentimes with somebody stole money investigation, you call the police, right? You may talk to your accountant or somebody first just to make sure you're on the right track, that you think you have internal theft. Hopefully you have the right controls in place not to have that. But I'm assuming we're talking about discrimination and harassment investigations. So who conducts that? That really depends on the nature of the claim. So I have conducted 1 million of these, or at least it seemed like 1 million. Usually when there were high-level folks involved in the allegations. Because if you're CFO or CEO, if you've got the astronomer CEO situation going, how do you as HR conduct that, right? There's an inherent problem there. You need somebody who's theoretically a third party, an outside third party, who's not bringing bias and not controlled by the CEO into the situation. Now, theoretically, the law firm has a benefit that the CEO is giving them the work, but still, they're more removed than the HR department. So if you have a high level situation, you definitely want to retain somebody outside of your organization. Also, because the liability is so huge in those situations, because the people you're dealing with, especially if you're at the C sort of suite level, make a lot of money. And if you're going to fire one of them, then that's, you want to try to protect yourself as best you can. And so some of the examples I've seen on this is like a VP having an affair with their secretary. I've seen the head of a nonprofit having an extramarital affair with the physician who was retained within the nonprofit. That one was particularly troubling because first it got reported anonymously to the board, and then there were several terminations, and those people said, hey, we were terminated because we were part of the anonymous reporting of this affair that the CEO essentially of the organization, the president of the organization, wasn't treating people well because she wanted to keep this affair secret. They get really, really messy. So, but let's say this is frontline worker, right? Theoretically, you're going to have HR, and ideally you have some type of witness, whether that's the person's first level supervisor, whether that's somebody higher up the chain of command. It just depends on how reliable you think those people can be to be witnesses and how good of a witness they would be as well. So really depends who can be the workplace investigator. I've even seen private investigation firms used. You have to use a quality one if you're going to do that. Can you require employee participation? So great question. Got this all the time when I was practicing. And the answer is, hey, we have a really serious situation. Usually it was the alleged perpetrator who didn't want to participate. And what we would say to him or her is, hey, Anne, you've been accused of sexual harassment. If you don't participate, then we have nothing to go by except what Joe is saying. And Joe says, Anne, that you kept grabbing his butt. So we're going to have um, nothing to go on except that. That's my first line of when they won't participate. And secondly, you're an employee. We expect you to participate. And if you don't, we will look at that as a disciplinary infraction. What do you say to employees before you even start questioning them? You have to set expectations. This is not necessarily confidential. It is to the extent possible, but it's not always possible because Anne's going to say, hey, if you talk to Doug, Doug's going to tell you that I never grabbed Joe's butt. And now I have to, as the HR person, go talk to Doug, right? This is confidential to the extent possible. Also, if Joe goes and files an EEOC sexual harassment suit against Anne, all the information I have is going straight to the EEOC, good, bad, or indifferent. And so there's no Fifth Amendment, there's no Miranda warning. This is not criminal activity, but we are going to tell them we will keep this confidential to the extent possible, but it may be released in connection with the investigation to oversight agencies or in the discussion of this, right? So it shouldn't be office gossip, obviously, but it's not as confidential as some people think it is. I want to touch on the Fifth Amendment just briefly here. I have seen that invoked somewhat correctly, believe it or not, in this type of situation, even though it's not a criminal situation. So where do I see this? Let's say there's assault. The alleged perpetrator in the criminal proceeding may be invoking the Fifth Amendment. They may, we had depositions sometimes where the person would invoke the Fifth Amendment and refuse to talk because of an ongoing criminal proceeding. So you can sometimes get that where there's a criminal overlay, usually involving assault or some type of significant legal misconduct. For instance, we had a case that involved serving drinks to minors, not Coke, rum and Coke. And the two employees were fired who did that. Now, that may seem like a no-brainer. The one employee turned around and said, hey, you fired me because I was over 40. That was a really poor case because the other employee we fired was like 30. But in any event, nonetheless, we had this case. Cases don't have to have merit to go to court. And those employees took the Fifth Amendment when we talked to them about whether or not in a deposition they served alcohol to minors or not. So occasionally you get that overlay if there's a criminal type issue going along with it. All right. This one I have heard misapplied a lot of times. So just want to clarify this. This comes, I'm sure, from the heart of some employer that wants to do well by their employees. And kudos to you. I admire it when employers are kind. I also always personally took the position that we deal with the bad apples. We make the rules for the 80 or 90% that do good by us as employees. So we have an employee here who has a child with a significant disability. Does the Americans with Disabilities Act cover leave time to care for the child or to flex the work schedule? No, not under the ADA. The ADA covers the employee only. It has nothing to do with spouses, children, grandparents, parents, my uncle's stepmother, anything like that. But don't forget, you've got the FMLA. In Pittsburgh and Allegheny County, you have the sick leave laws that would cover some time off for this, unpaid, but it would cover some limited time. But if you have an employee who comes to you and says, my child is disabled and needs to go to ABA therapy, twice a week, I need Wednesdays off, or I need Wednesday morning off and Friday morning, whatever it is. The ADA is not going to require it. They'll have some time available to them through the FMLA, and if they're an FMLA employee, and in Pittsburgh and Allegheny County. But let's assume there's a non-FMLA employer and we're in Butler County. There's no right to this, assuming that we treat everybody the same. So assuming that we don't like let Joe off to go grocery shopping Wednesday and Friday mornings or something, we don't have to let this person take time off to flex their schedule, to take their kid to ABA therapy or PT or OT or whatever it is that the kid may be in. Now you may be sitting there and saying, well, that's cruel, Ann. I'd want to do that. I'm going to let them flex their schedule. That's fine. Just keep in mind that what you do for one, because you may say, well, Joe's our best employee ever. He's worked here for 15 years. We want to help him. He's a great employee. What you do for one, you're going to do for any similarly situated employee. So if Joe's a customer service rep, we're looking at that pool of employees, not necessarily those with a lot of tenure, but any customer service rep. If we say, hey, Joe can flex it, we need to be prepared for Ann to want to flex that too, and have to say yay or nay at that point, and recognize that if we say nay to Ann and she's similarly situated and has the same sort of problem with a kid, wants to take the kid to speech therapy, same idea. We've probably got a discrimination suit that's going to be tough to defend if we don't let Ann do it, even if we think Ann's kind of flighty and not our best employee, and we really don't want to do it for her because she might be milking the system. So just keep that in mind, that what you do for one, you're going to do for others who are similarly situated. If you think there's fraud involved by Ann, that's a different story. We address that separately. But in general, we're going to allow that to happen. Okay, onboarding. So good question here. Is it okay to ask all employees to complete an I-9 electronically and update everyone to electronic records coupled with E-Verify? So let's talk about this. I think maybe we need to sort of tweak this question a little bit to make it clearer. First of all, can you ask all employees to complete an I-9 electronically? So this is the form. It's not the documentation that you need to look at, right? We're talking first about the form. I included, if you search that 10.1 form I-9, it will tell you everything you have to have in place to do electronic form I-9s, whether that's for current employees or applicants, whatever. There's certain bells and whistles that you have to have. You can't just say, hey, I made a form and I put it on my computer, and now I'm going to have everybody do it. No, you have to have access controls to ensure integrity, and that would make sense no matter what. You have to have some level of security on it. There's different things like that. You can't change the form dramatically from what the paper copy is. So if you look at that, there's sort of like a checklist of things you have to do in order to keep I-9s electronically. If you meet all those bells and whistles, then yeah, you can do it. Now, we haven't gotten to the documents though. That's different, and that's where E-Verify comes in. E-Verify is optional in many states. It's required in some states, and in Illinois and California, they have a problem with it. So you first got to know what state you're in, whether you've got any issues using E-Verify or whether you're actually required to use it already. Secondly, if you use E-Verify, you're allowed to do remote verification of the documents that you would look at to make sure that Ann Lavelle is a citizen and hasn't, snuck in from Canada or something, and that I'm legally allowed to work here. So that's where E-Verify in the electronic I-9 thing, I think, is getting sort of maybe muddled there. The E-Verify is necessary if you're doing remote verification, which means I'm going to call up the person, set up some sort of Zoom link, and look at your documents and stuff like that, or use something along those lines. So if you're going to do remote verification, you must use E-Verify, but again, keep in mind state law varies, even though this is a federal law, because federal, it's more or less optional for most things. All right. Also keep in mind that E-Verify does provide some good faith defenses about who you've hired. If it turns out that Ann Lavelle really did sneak across the border from Canada and is working for you illegally. If I've sort of checked all the boxes on the E-Verify and slid through that system, and somehow ICE raids you and finds me working there, it provides you with a good faith defense, because that is something, and I should have mentioned it in the ICE slide, you know, there's penalties for the employer. Forget the fact for a second that they may round up your employees, right? And say, hey, they're all illegal. They're all working here. We're taking them away. That's one huge issue. The fallout for you as the employer is, if they're illegal, you probably didn't do the I-9s, right? You probably don't even have the I-9s. There's huge fines for not doing that. So the folks that you've seen on TV with their businesses getting raided, that's just the tip of the iceberg. The reality is fines that come down the pike, the investigation that comes down the pike after the raid, that's directed to the employer, not the illegal immigrants who are working, that says, hey, you blew it as the employer, and now you're subject to all these fines. Okay, dress code. Can any employer still have a dress code? My first question to you is this really that important to you? Whenever there is a market where it might be difficult to find employees, I'm old enough and talking with my parents, who are actually descending on me in about 2 hours here. Pray for me. Okay. We won't go there. No, they're great people. I just had to make that joke though. Back in the day, shall we say, you could ban tattoos and piercings and whatever it was, right? And that has become a lot less common these days to ban stuff like that, because the reality is they're more prevalent. And if it is a job seeker market, an employee market, maybe you should take the person who has, the full sleeves, because hey, they're a great employee, and who cares if they have the tattoos. I think what this question, though, really goes to is there's two main issues here. One is hair. So Pennsylvania recently passed the Crown Act, which protects almost all ethnic hairstyles. The exceptions are health and safety. So if you had a rule right now that said male hair length has to be, earlobe or above, and you had an employee who had dreadlocks that are longer, I think you're going to have a really tough time enforcing that given the new law, because that's going to be perceived as an ethnic hairstyle that has protection. And you're going to have to show that there's some health and safety reason for it. And, with health, there's hairnets, right? That is the typical, especially if you have females in the place that have longer hair. You make them put it up in a hairnet, you're going to make that guy put it up in a hairnet. Same thing with safety, right? If you're working with lathes or saws or whatever it is, yes, there's a safety aspect there, that we don't want somebody's hair to get caught and pull their head down. Same thing though, you can have rules about having it tied back for health and safety rules, or up in a hat, or whatever it is that, you need to do to make the workplace safe. It has to be applied across the board, so that the woman with long hair who is Caucasian is treated the same way as the man or female or whoever who has some ethnic hairstyle that's longer and not traditional. So, there's certain things that, yeah, we can apply across the board, like cleanliness, clean uniform, all those things. But when you get into looking at ethnic hairstyles, you're going to have a really tough time trying to ban any of those hairstyles, or say they're too long or whatever. The other place that I've seen this come up is we maybe have a rule that women have to wear skirts and one wants to wear pants. I think you have a huge problem trying to enforce that these days as well. The flip of that, of course, is a trans person who wants to wear the opposite clothing of what their biological sex is. I hope I'm describing that well. I think you've got an issue right at the moment, at least in Pennsylvania, with that, if you don't let them. So if I am, that may be pants for everybody then. So we don't have any issue if we find that repugnant to have the trans, I'm getting my words tangled up, but the biological male wearing a skirt. If that is repugnant to us, then maybe we go with all pants for people or whatever it may be. And again, we can have health and safety rules here, right? You can't have loose baggy clothing. We don't need to see your underwear, no matter who you are. Different things like that. It can't be too tight. It can't have messages on it that are inappropriate. Watch the messages though, because if they support a union or something like that, you can have issues if you let other people wear like "Have a nice day" or whatever on their shirt, and they say, "Hey, I support SEIU," whatever. It's sort of an all or nothing thing there. So you can have restricting offensive messages, but if you're going to allow any messages on t-shirts, then they get to wear their union shirts too. Okay. Let me go up to the one question we got. And if anybody else has a question, please feel free. So, what about a teacher that leaves because she does not feel safe in a classroom, that a child can escalate and throw things, hit, etc.? There is an IEP and they have a behavior plan and support person, but pretty new in the process of implementing all this. Okay. So I think this is a great question. This goes back to the unemployment, and this would be true in any workplace setting where the person or the employee said, "I don't feel safe for some reason." In this case, the teacher says, "I don't feel safe because we have a child who I'm going to assume has a severe behavioral problem. If we have a positive behavior support plan in place, maybe an emergency plan, whatever it is." Can you tell I've been around the block with IEPs? So in any event, one, we always look at the type of job as to whether something is necessitous and compelling reasons. And let me just use some hyperbole here. If I was a mechanic, I can't leave a job because I say, "Hey, I get grease on my hands all day long." But if I was an office worker and for some reason there was grease all over the place, I might say that's a hazard. It's an occupational safety issue. Maybe I do have necessitous and compelling reasons. So the first thing is teachers of all types, and I'm not just saying this because I'm a parent of kiddos. For those of you who have heard me talk before, a parent who has kiddos who have a positive behavior support plan at the Children's Institute. So I'm not saying that for this reason, but all teachers have some training in college of special education, right? Now the question becomes, what is reasonable and what is not reasonable, right? And so you as an employer do have an affirmative obligation to provide a reasonably safe atmosphere. Again, what is reasonable? That is the conundrum that you're going to get into here. If this person has already left, I would contest that unemployment, right? I would say, "Hey, she didn't give it a chance, or he didn't give it a chance to work." My husband's a teacher, so I can't exclude men here. I'd give it a chance to take effect, right? I don't think you can walk out. You can also argue, gosh, very common these days, our building has security guards, it has police, it has whatever, school resource officer. They have to give it a chance to work. You cannot run at the first sign. And I think there's pretty good case law on that, not just for teachers, but just in general. You can't run at the first sign of, "Ooh, there might be a problem," right? And part of what I would, look at here is the age of the child. Are they throwing things directly at people? Probably, given what's going on here. I personally would contest it because I wouldn't want a finding out there necessarily for other teachers in the same situation to hang their hat on. But of course, it depends on resources and what you want to do. The question here is reasonable. What have we done, right? What avenues did this teacher take if she or he didn't feel safe to address that situation? Okay, the other one somebody said, "As a parent of a trans child, you are doing great. Thank you. Thank you for your wording." I really do try with my wording because I don't want to offend anyone anywhere at any time. And I mean that from the bottom of my heart. So thank you for that compliment. That means a lot to me because no matter where people stand on things, I truly think kindness should trump all. And I don't mean President Trump right at the moment. And I'm not knocking him either. So in any event, I'm so glad that I can do this in a way that's not offensive, hopefully, to everyone. All right. I hope that kind of answers Oh, we had one question come in at a last minute right before we started actually this morning. Let me address that. Background checks. What's new with background checks was the question. So I'm going to assume that we mean recently, like in the last month or so here, and not clear back to Sandusky in 2012. So background checks, we had a law pass that's known affectionately as the Clean Slate Law in Pennsylvania. There were already ban the box laws in Pittsburgh and Philadelphia for certain situations. Pittsburgh, it applies to public employers and subcontractors. Ban the box means you can't ask about criminal history on the application until you've made a conditional offer of employment. The Clean Slate Law, not to get into the weeds here, but essentially provides automatic sealing of certain criminal records, whether it's a summary offense, which in Pennsylvania is sort of the lowest level thing you can do wrong, a misdemeanor, which is one step above, or a non-violent, non-sexual assault type of felony. The records are automatically sealed after like 3, 5, 7, 10 years, depending on the nature of the offense. And so summary offenses, which again are really low level, I've done something pretty stupid, probably I was a teenager, those will get sealed automatically without petition of the individual, in most cases, after 3 years. What does that mean as an employer? It means you can't see them, right? Same thing if my misdemeanor gets sealed after 5 years, or if, okay, I don't know if you can see this, but the save the date holiday party here at CTR just came up. So obviously that's critical, but we'll keep doing this for a little bit. So, you as an employer can't see that. Now, the Clean Slate Law also came with some provisions to protect employers. So if you hire Ann Lavelle, and turns out I was a bad guy, but all my records got sealed, and I do something at your workplace, you have a protection that says, hey, I couldn't see her records because they were sealed. So I'm not culpable for whatever in the world it is that Ann pulled at the workplace when she ran off with all our money or whatever. That's not our fault. Now, it doesn't change your obligation at all to look at the records, particularly if you're in certain industries like, childcare, elder care, it's schools, etc. That didn't change any obligation along those lines. It just changes what you can see and your liability if you hire somebody despite a record being sealed. So that's the clean slate record. That's the big change out there with respect to background checks. I have to get on my soapbox though for 1 second and talk about something I saw all the time. For companies that are required or wanted to do background checks, first of all, the background check has to be related to the nature of the job, right? And so if I'm just working on your assembly line, running my criminal record check for DUIs has no relation to the job because I'm not driving for you. If I'm driving the work van, then yeah, absolutely. And if I have 10 million DUIs, you have a reason not to hire me. But what I would see happen with fair frequency is we are desperate to get somebody to drive our van. So, hey, Ann walked in the door, we're hiring her, and we're going to run the background check. We're going to tell her we're running the background check, but we're going to let it work for like 2 weeks before we get around to running the background check. And then when it comes back that Ann has 100 DUIs, somehow I still have my license, we want to fire them. That's a tough defense situation. Your attorney will hate you for this. If it's important enough to you to want to exclude somebody as your employee because of their criminal record, you need to position yourself well and run that, no matter how desperate you are for the van driver, before you hire them. Because Ann's argument and response is going to be, hey, I've been working here 3 weeks, driving their van. I haven't been drunk once, and I haven't wrecked their van. And if this really was job related, and if it really was that important to them, they should never have let me drive in the first place. That's a tough defensive position. So run those background checks before you let the person start to work if it's really that important to you. One more question came in. Are non-compete agreements still legal and enforceable? Yes and no, it depends. So this has always depended on the jurisdiction that you're in. They've never been really enforceable in California. In Pennsylvania, they are, but in Pennsylvania, we had a relatively recent law come out with respect to healthcare providers. Really difficult to enforce a non-compete against a healthcare provider now. You basically can't, except in very limited circumstances. But if you're referring to the FTC rule that they wanted to ban all non-competes, that seems to be dead. So you're looking jurisdiction by jurisdiction, meaning state and local jurisdictions now, as to whether you can do this. And as always, non-competes have to be narrowly tailored. If your non-compete is over a year, I'd be careful of it. If it's an all-nation non-compete, you have to be prepared to defend that. And that can be tough to do if I'm the worker based in Pittsburgh. So just be reasonable in your non-competes and know the jurisdictional law, and you can still have them. And of course, with a non-compete, you should also have, non-disclosure, confidentiality, whatever it is, non-solicitation. Because sometimes even if your non-compete gets thrown out in court, some of those other provisions can be just as good to enforce if you've got them in your contract. And keep in mind, you want the non-compete signed before the person starts. Okay, I think that is it. So everybody have the best of holidays. Merry Christmas, Happy Hanukkah, Happy New Year, Happy No Holiday, whatever it is. Enjoy, and I hope all good things for everyone. Okay, take care, and we'll see you in January.